So for this afternoon, we're pleased to have Dr. Mark Frankle, who is speaking to us. He's the director of the Scientific Freedom, Responsibility, and Law Program at the American Association for the Advancement of Science. Dr. Frankle received a BA in Political Science from Emory University, a PhD from Political Science with a concentration in Science Policy from George Washington University. And today he's going to be talking to us about the brain on trial, how neuroscience challenges the law as we know it.
All right. Well, I'll thank you again for that very warm welcome. I do want to make a correction, though, in my title. I don't know what happened with the AAAS website, but I actually have a different title because on June 1st we merged a couple of programs at AAAS. So my title is Director of the Scientific Responsibility, Human Rights, and Law Program, and why I'm particularly pointing that out is because today's a very special day worldwide. Does anybody know what today is? Today is Worldwide Human Rights Day, where people all over the world, including the United States, are celebrating human rights. And of course, we know that there are many people who are not as fortunate and able to do that. But we had a program at AAAS yesterday which was focused on anybody who wanted to come to offering them training in how science can be used to promote human rights throughout the world. Before I get to the neuroscience part, it's coming, I promise, I just want to set some context more generally about the relationship between science, technology, and law before I get to neuroscience. So here's a quote in 1998, one of the few, maybe the only Supreme Court justice who was published in Science, the journal, I don't know. But Justice Breyer made the observation, as you can see there, that increasingly the courts are dealing with issues related to science and technology because science and technology are increasingly becoming embedded in all sorts of things that we do as a society and individuals. So I think it's fair to extrapolate, although that was in 98, to say that it's probably even more so today. In fact, I know that he would say the same thing today as he said back in 1998, that the judicial system, the legal system generally, is being challenged, if you will, by a variety of advances in science and technology. I'll be focusing on one of those today. But again, before I do that, a little bit more context, if you will. One of the things that I'd like to point out at the beginning is that in many ways science and law are very different. They're different in terms of their values, their cultures, and both of those things affect the way they operate. And they operate a bit differently than each other. And I wanted to point out some of those differences because during the course of my comments, you will actually see how that is happening in the context of neuroscience and the tension that sort of exists between science and law. But at the same time, there's certainly some overlap. And as we well know, that science has already made a considerable amount of contributions to the legal system outside of neuroscience, DNA analysis being one of the most significant of all time, I think, in fact. So let me run through some of these things. The science, of course, is searching for general principles, whereas the law is focused on particular cases. I mean, when a judge has to make a decision, it's in this particular case. That's what he or she is really concerned about with regard to how the science might or might not influence that particular case. As scientists, maybe it applies to that particular case, maybe it doesn't, but that's not the kind of answer the judge wants to hear. Second, science is open to revision over time based on new evidence, whereas the law has a need for closure in a specific limited time frame. I mean, all deliberate speed in reality may not be followed as much as we would like, but that's what we're entitled to constitutionally, a trial that moves ahead and can't wait for the science to come up with a definitive opinion. So that's a big difference. We're always saying, well, give me another 2 or 3 weeks in a laboratory. The court system can't wait for that, and if you're the one on trial, you can't wait for that either in all likelihood. Science's pushes for innovation, the law's deference to precedent. The courts will tell you over and over again that they go back to what the other courts have said in the past in deciding decisions. They may or may not be helpful, but they look for things. They don't like to be revolutionary in their decision-making process. The courts don't like that. They like to move incrementally. Science would love to be revolutionary, particularly if you're want to get tenure or want to get a Nobel Prize, and it often is. The law uses science to serve client interests. Science has no such loyalty. We aim more broadly. Now, of course, there are exceptions to all of these. If you work for industry, then maybe you do have a client. But generally speaking, you think about these as two institutions, science and law. I think it's fair to say that this is an accurate statement. The law is very specific and uses science to serve client interest, and that's important to remember. The law supports a commitment to advocacy, whereas science seeks a more independent, objective approach, which is not to say that scientists are not advocates for their work. But it is to say that, generally speaking, the systems work a little bit differently in that regard. Science considers all the evidence, at least in principle, that's what we would like to think, disconfirming as well as confirming. The law, however, only considers evidence that is admissible according to very strict standards that, in some cases, are just very much unaligned with what science uses. Admissible is an important factor. I'm going to be talking more about that, but the reason that's so important is because what gets into a trial or what doesn't get into a trial can really have a profound effect on outcomes. And so if the scientific evidence is admissible, there's certainly one party in that litigation who's really happy about that, and maybe another party who isn't. If it doesn't get in, then maybe their feelings are reversed, if you will. So this is a very important part, admissibility. If it doesn't get through the admissibility hearings, and I'll say more about that, then that's it. It doesn't play out later on in any kind of trial, if you will. So those are the differences that I wanted to point out. Again, noting exceptions, but generally speaking, they work in two different spheres, two different domains. We at AAAS got interested in neuroscience in the early 2000s. We had been focusing a lot in the 1990s on genetics. You may have heard something called the Human Genome Project, and there's a lot of interest in what some of the interesting policy issues would be. But when we were looking for where we go from here, which was back then, we decided that neuroscience opened up some interesting avenues and that there really wasn't anybody looking at how neuroscience would affect the legal system. There were some people who were thinking deeply about what they call neuroethics, some of the ethical implications, but people weren't looking at it yet. And AAAS has had a joint committee with the American Bar Association since the 1970s. So we had an infrastructure whereby we could use it to collaborate with and communicate with lawyers and judges. And in fact, in the 90s, we had projects involving lawyers and judges. So we decided to convene a meeting. It was a workshop in 2001 to take a look and flesh out some of the legal issues. We had several federal judges, a number of attorneys, both prosecutors and defense attorneys, as well as philosophers and neuroscientists. And in 2003, we published this report, which summarizes the proceedings, but also includes some commission papers, really in-depth analyses of various perspectives that were presented during the course of the meeting. So that takes us to neuroscience. Here are just a couple of what are, I think, a great number of claims that are being made by people who consider themselves knowledgeable about the fields, both neuroscience and law, about the impact that neuroscience will have on our legal system. I think it remains to be seen as to whether or not that's the case, but for some people, they're looking at neuroscience as maybe, just maybe, the next DNA technology with regard to its impact on the legal system. I think it remains to be determined, but I am persuaded by my own work in this area to the fact that I do think it is going to have some significant impact, but we have to be awfully cautious. Remember, there's a lot at stake in legal deliberations and proceedings, all the way from probation, imprisonment, of course, and then capital punishment. So while there are a lot of people who are advocating for more and more neuroscience, judges should be more educated about it, should know more about it, so should attorneys, etc. We have to be a bit cautious, at least at this stage. And I hope I can convince you that there are potentialities, but at the moment, we have to be quite cautious about that. Okay, uses of neuroscience in the legal system. I just want to make sure that we have this ground covered. You can use it in a variety of ways to evaluate one's mental state to stand trial, to be convicted of a crime, sign a contract, draw up a will, or be executed. There are all sorts of different ways in which neuroscience might be used in the system. Investigations by law enforcement, that is in the investigative process. You probably know that there's a lot of use of DNA technology now early in the process. You also know, of course, there's a lot used later on when we have to exonerate people who've already been in prison and falsely convicted. But there is that possibility of using it at the law enforcement stage. Personal injury claims, disability benefits, another place where it might be used. This is Social Security hearings. Assess future dangerous. Not a trivial matter. Whether a suspect or defendant is telling the truth, not a trivial matter. And sentencing decisions with either mitigating or aggravating factors. And so there are different ways, and we're going to touch on a number of those as I proceed during the course of my comments. For those of you not familiar with the legal system, they're basically 3 stages before you get, for a case to really run its course, before it gets to the appellate system. So we can use it in the pre-trial phase. This is the investigation I mentioned and admissibility to which I referred. Then you can use it in the trial phase to help determine guilt or innocence. And then you can use it in the sentencing phase to, as I said earlier, lead to mitigating or aggravating circumstances. And we're going to cover all of those, in part at least, during my presentation. So the pretrial investigation, where police, prosecutors, defense attorneys can use it to assist with collecting evidence, use it as a negotiating chip for deciding whether to charge, in the prosecutor's case, to charge or what to charge, or perhaps as a plea bargaining tool because of what it might or might not reveal. And again, we'll get to those substantive matters momentarily. But these are the kinds of ways in which it might be used. That's the way all evidence may be used. And there's nothing unique about neuroscience in that particular situation. Then there's the admissibility phase. And this is where I want to spend a little bit of time because a lot is happening in this area of admissibility in neuroscience that I don't think is that well known. First, a little bit of history. In June 1993, the Supreme Court issued this decision, which some people call the most important decision affecting science and the legal system in history. Remains to be determined by others. But what it did do is the court offered 4 criteria for determining whether science was admissible. Now remember the importance of admissibility in litigation. Whether or not the science was admissible. And here are the 4. Is the evidence based on a testable theory or technique? And by the way, I hope all 4 of these will be familiar to you. Has the theory or technique been peer-reviewed? In the case of a particular technique, does it have a known error rate and standards controlling the technique's operation? And is the underlying science generally accepted? So that's the sort of the 4-prong test that the Supreme Court has established. All federal courts follow this. Some of the states don't have to. Because they have a different system with regard to admissibility that I won't get into unless people are interested. But most of the states, I think, are what are referred to as Daubert states in the sense they follow that as well. So, I mean, here was, the court was basically having to deal with a lot of these cases on an ad hoc basis with regard to how evidence was going to be admitted with regard to highly technical evidence, and finally decided that there had to be some sort of guidance given to judges. And by the way, the AAAS has submitted an amicus brief in this particular case. We thought it was particularly important. But keep in mind that even if you meet all of these four, and this may be obvious, the science and technology evidence that you're planning to introduce must be relevant to the legal matter under dispute. That is, a judge also has to determine, okay, so this is the science, this is the best science out there, but is it relevant to this dispute? Attorneys, you have to convince me. Okay, so that's another barrier the legal system sets up. And you might think, well, what, if attorney's introducing it, of course it's relevant. No. You remember how many of you are not trained as lawyers? Have you ever encountered a lawyer? They, if they're good lawyers, they're basically your advocates, zealous advocates for you, and they're looking for all sorts of things that they can use to make a stronger case on your behalf. And when you see some of the things in the past that lawyers have proposed to introduce, they know this is not relevant, but it takes time, makes delays. Maybe they want delays for some reason. Or maybe they think all of this stuff, if you will make it less clear to the opposing side as to what is the relevant stuff, and they'll let it in. But in any event, it's part of a strategy. So that's a very important rule if you're a scientist and you're interested in the legal system. Now, the reason I said I'm using this is because this particular technology, neuroimaging of brain scans, is reflected in these three, and I'll mention them briefly in a moment. This has begun to receive a lot of attention in our legal system. And depending upon, in a sense, this is sort of the hierarchy, with FMRI being at the top, although it's not at the top of the slide. But chronologically, in terms of discovery and implementation, these are neuroimaging technologies, and CAT scan, which I suspect most of you are familiar with as patients, they have been introduced in the legal system for over a decade. The difference here is these two are basically structural imaging. That is, they examine parts of the body and tell you something about the structure. So, for example, if you have a tumor pressing against the brain inside, they can identify the tumor. If you have a broken bone, they can identify the tumor. These three, PET scan, SPECT scan, and fMRI, they are more functionally oriented. That is, the intent is to tell who's ever observing the scans what is going on. And you see, just literally, you could see hundreds of scans taken over certain time intervals to see how things are changing. So you might have something happening in there with regard to the firing of various neurons that is causing some symptom, whatever that might be. That won't be picked up by a CT or an MRI. It can be picked up by one of these three, because they're more interested in function, what's happening. We're interested as scientists in function as well, because we want to make some claims at some point in time about how things function here that lead to certain behaviors, learning disabilities, whatever your interest might be. So these are the ones that are the more interesting ones, I think, in terms of legal cases. But I do want to mention, just generally speaking, that these two, they find a structure in your brain that looks a little bit odd. That's it. They found it. In this case, these are looking at function, and they actually are representations, or ultimately statistical representations of what's going on in the brain. And they compare a statistical average, if you will, with that individual. So you have to be very careful in interpreting these scans, because with regard to that person who's standing trial, for example, they'll take a statistical representation here, and they'll compare it against what's going on in his or her brain. But it may not correlate, if you will, with what is considered to be some sort of a symptom or function or behavior. That is, the conclusions that we can draw from here, we can generalize a bit, but when we get to any specific person, it's almost impossible to say, well, that's what caused him to get upset and strike somebody, or that's what led him to rob a bank, or whatever the case might be. So these are statistical representations. They're pretty pictures that you can create, and you have to be very knowledgeable on how to interpret them, and I'll get to that in just a moment. So with regard to admissibility, having just mentioned those, here are some civil cases and here are some criminal cases, and you can see some of the dates, all relatively recent. Here's a case whether brain imaging could be used to show that exposure to violent video games increases aggressive behavior in adolescents, an issue that's been with us for decades. And the psychologists have been working at it, if you will, but they never had this kind of technology before. Here's a case where brain scans presented to support entitlement of a former football player to disability benefits. On brain images introduced to prove mental incompetency to void a contract. Again, all reflecting some of the ways I mentioned earlier that they may be used. In the criminal case, here's one where it's used as evidence of incompetency to stand trial. Okay, so that's before we even get to the trial. Here's a case, brain imaging presented to support an insanity defense, and brain images used as mitigating evidence in sentencing for a murder. So they're being used. They're certainly being used. I can tell you, though, that none of these final decisions, and I don't remember how they all worked out, none of them were based on the imaging evidence alone. There's no reason to believe that the imaging evidence was that compelling, but nevertheless it gives you an idea of where it's being, kinds of cases in which it's being used. So the point, I think, is to make that while all of this has happened within the last X number of years, there is a belief that as the science gets better, we'll probably find more and more lawyers looking for reasons to use it. So I think the future, you're going to see wherever you saw 6 total cases, you might see 30, 40, 50 if I were to come back in a couple of years and give the same talk. So I think we have to keep that in mind. While we might be cautious, the science is getting better. And to the extent that it can demonstrate that it is indeed measuring and identifying what it claims to be measuring and identifying, that could have more and more use in the context of the legal system. So now this takes us to what is probably the most controversial use of imaging in the legal system. Anybody have any thoughts or ideas about that? Okay, well, I won't keep you in suspense. Whether or not FMRI, functional FMRI imaging, can help determine whether or not someone is lying, deceiving you, telling the truth, however you might want to look at it. This is becoming a big deal, and to some extent it's being driven by the private sector. That is, commercial outfits looking for a way to make a killing, if you will, financially on this technology. So here's a couple of examples. One of the companies is called No-Lie FMRI. No-Lie, cute name. Note here, I don't know whether you could read it, but listen, this is a claim they're making on their website. The technology used by No-Lie MRI represents the first and only direct measure of truth verification and lie detection in human history. And they even added an exclamation point there. This is the other competitor in the field, CFOS, and they have their own claims that they make. They want to provide comprehensive lie detection, truth verification services. That's what they provide for you. And at the very bottom, they talk about the fact that we provide independent scientific validation that someone is telling the truth. Well, there'd be a lot of spouses, I suspect, interested in this technology. But those are claims that they're making, and they are trying their darndest to get this into the legal system. I will say that they are having some success in getting it into some agencies of our government, such as the Department of Defense and the intelligence agencies, who are very much interested. And as you know, a number of agencies use polygraphs now as part of a screening process, and there's very little respect for polygraphs in the scientific community or in the legal community for that fact. But nevertheless, they are managing to make a case for themselves, if you will. Speaking of polygraph, this is what it takes to do a polygraph, and this is what it takes to do an FMRI. The cost is considerably higher here, obviously, and it's not quite as mobile as this. However, there are people and companies, very respectable companies, who are working on trying to develop a mobile FMRI that really is easy to take around, and as opposed to some machine like that, which basically has to be set in place. The difference that I might point out to you is, and you probably know this, the polygraph is sort of a response to various questions that people answer in order to get some physiological responses, in the belief that false answers can be distinguished from true answers due to differences in these responses. So I'm sure you've all somewhat acquainted with that. That is, polygraph is unacceptable in any federal court in the United States, and there's only one state that I'm aware of. Any of you from New Mexico? Okay, I can say it then. New Mexico is the only state court that allows polygraph evidence in state trials. And there have been a number of reports from the national academies basically shooting down polygraphs as anything more than flipping a coin, if you will. But polygraphs, as I said, are used throughout our government for screening, employment screening process. And they're also used by industry for that purpose as well. The fMRI is seeking to identify areas of brain activated when trying to do something other than tell the truth. So instead of saying, try to verify truth, they're trying to find out when you might be doing something that's not the truth, such as lie, deceive, or mislead. The reason for this is that the brain has to work a lot harder to lie, to make something up that you know is false. So that's sort of the different ways in which they try to get at this question. Yeah?
Does the brain still have to work a lot harder if it's a lie you've told before and you've already gotten comfortable with it, and then you tell it again under this circumstance? How can it distinguish?
No, it gets easier.
Yeah.
And of course, psychopaths do it very well.
So then this would not be...
Well, I mean, I haven't finished my talk yet.
Oh, sorry.
I haven't even gotten to the punchline yet. No. Yes.
In a polygraph, the tester asks you these individual questions. But in that machine, no one's asking any questions. They're just throwing it back.
Oh, no, they're asking you questions. You're sitting in there, and they have it hooked it up so that they can ask you, what is your name? And they look at the imaging as it's appearing before them. Where do you live? Did you shoot your mother? Those kinds of things. It's not quite that dramatic. And in a moment we'll get to some of the problems associated with that methodology, but that's what they're doing. What's going on in here when you have to think and ask and answer a question? Yeah, and then it's back.
Regular MRI with the banging and the knocking going on that usually associated with?
It's a little bit quieter, and it depends. These machines are made by different companies, and some are better than others. But clearly these, by the way, I should say that while the MRI is part and parcel of medical care in the United States, this fMRI is not used for medical care. It's research-oriented, although there's clinical research going on with it.
Excuse me, with regards to epilepsy, it is sometimes used for clinical purposes and not just research.
Good. Okay. So that's an example where it is used for clinical purposes. There is clinical research going on. But for the most part, this is used for research. There was a comment, a question?
I just had a question about if you're a pathological liar, does that change? Will be something different going on in the brain that wouldn't be measured?
We believe so, yes. So, I mean, what if you ask somebody, are you a pathological liar? And he says no. I don't know what shows up in the image, but all right. So there are some images that can indicate, going from 1 to 3, how different activity, depending upon the question you're asking, different kinds of activity go on. And scientists, much more skilled than I am, can interpret these in a way that hopefully are responsive to a research question that they have asked, or maybe a clinical question. But in the legal context, the law would ask questions. We need to know whether something is true or not. So anyway, let me go on, because I am going to spend a little bit of time on this. This is 2 very recent cases of where FMRI evidence, not scanning generally, there have been attempts to get it into the court. This is a state case in New York. It's an employment discrimination case. The plaintiff sought to introduce the results from the imaging to confirm that another witness, not this person, but another witness was telling the truth, because it would support her position, whatever it might be in terms of discrimination. This is a case in federal court, and it was a Medicare-Medicaid fraud case where the defendant wanted to use the results from imaging to demonstrate that he was being truthful when claiming that he did not intentionally defraud the health care benefits program. Neither one of these were successful in terms of getting it admitted. And this again was introduced at the trial phase, guilt or innocence, and neither one was successful. The judge in this particular case, this is the Tennessee case, the federal case, really wrote a very substantial report. I think it was 51 pages. He was a magistrate judge, which often assists federal judges in dealing with highly technical matters. They have certain expertise. And he wrote an excellent report on some of the issues associated with the problems in using this particular technology in the legal system. So it's always possible, of course, that we'll get better at this. And so here are some of the things that I'd like to suggest sort of require science to do before the legal system should be seriously thinking about how this technology might aid them in their decision-making process. And as scientists, I hope a lot of this looks familiar, although it's applied to this particular technology. The images depend a lot on the design of the study, the data collection, analysis, interpretation. So as I've said before here, no particular brain image has any inherent significance. It has to be interpreted and understood what's going on there. And that's the first of several points that are going to make sense, I hope, as we go along. Typically, brain imaging are done at understanding how the average brain within a research sample is activated. From this, one cannot assume that the average of the group will be representative of any individual in the group, or that a scan of a specific person tells us anything about how other brains in the group will be activated. So at this point in time, what scientists could tell you to a limited extent is that there's a statistical understanding of what that particular image I'm looking at represents based on some sort of average. But you can't take a scan of a particular defendant and make some sort of claim, or you can, but it's not going to stand up, make any claim about that particular individual. We still have a lot of basic science to understand. Also, the distinction between abnormal and normal with respect to brain function is not always clear. If you look at two brains and one seems to be operating in this fashion, this one in another fashion, it may, and there's no symptomatic behavior. Are you to say that one is normal, one is abnormal? Now, at some point in time, and in certain extreme cases, we can make sense of that in terms of insanity, for example. But generally speaking, we still have a lot to learn about the way the brain functions. We know a lot about structure, but about the way the brain functions. So we're still working on that. The research relies on a narrow segment of the population. Most of the people studied are college students. And that's true throughout the world. Someone did an international study of who the subjects were in FMRI studies and found that it's true no matter where they're doing the studies. we have a captive audience
Probably
here.
true of psychological studies in general.
Yes, sir. Yes, absolutely true. Well, it is. Yes, it is true. So that's could be an issue in terms of developing norms. The experimental studies are small. Most of them have ends of under 20. These machines take a while to calibrate, to understand, and using I mean, some of your subjects, of course, will not be happy sitting in one of those machines. It's much different. If you've taken an MRI, you understand. And they just simply don't have many, if any, studies that I've seen that even come close to three figures, like 100 or more. But nevertheless, what they're trying to do is establish some base knowledge about the possible potential value of using this technology. I think, and they're expensive to do as well. So I think eventually we'll go beyond this, and I think we'll eventually go beyond this. But at the moment, most of the studies in the literature have very small ends. The context during the research is artificially created by researchers to help them answer some sort of question or questions about their inquiry. So, researchers might put a student in room A and a student in room B and say to A, if you don't eat that cookie that's sitting there, I'll give you $50 at the end of the experiment. And say to B, if you don't take that watch that's sitting there, I'll give you $10 after the experiment. But the watch is worth more than $10, so he takes the watch. Okay? And then when again, all of this is understood as sort of an artificial environment. And so then when he asks the people puts them in the FMRI and asks the question, well, did you eat the cookie? Did you take the watch? Whatever the case might be, it doesn't matter what the answers are. The point is it's all artificially created. It's an environment much different than somebody who really doesn't care whether he hurts anybody, really doesn't care whose property he takes, really doesn't care, et cetera, et cetera. So the scenarios that we are creating in these research projects to study things, is he lying or is he not lying, are really artificially created, and we don't know whether we can take that and apply and extrapolate to the real world. We're still trying to figure that out. We also have very limited knowledge about countermeasures. That is, how easy is it to basically fool the device and the researcher? We don't know. We talked earlier about psychopaths. We know a lot about them, but take a look at the, quote, normal population. We just don't know how easy it is to mask what the truth really is and fool. And that we need more studies like that. And again, even if you do them in an artificially created environment, will they be extrapolated to the real world? The brain changes over time with experience, so that a scan today is not conclusive evidence of what the brain was like when he or she committed the crime. I mean, there are sometimes, as you probably know, there's a crime. It could be 2 years before someone comes to trial, or 6 months, or whatever the case might be. And you show a scan to a judge or a jury 2 or 3 years afterwards, the opposition is surely going to raise the question, well, how useful is this when he committed the crime 2 or 3 years ago? So that's an issue that we have to consider, again, in the context of the legal system. All scanners are not the same. They're built by competing companies, calibrated by different sets of people and standards. So that raises some questions that I think we have to pay attention to as well. And this is the big one, I think, really, is linking any kind of neural activity in the brain, in specific regions of the brain, to a certain kinds of behavior or cognitive function, such as lying or truth-telling, is not fully understood. We still have a long way to go in terms of determining, is there some place in the brain which is the lying place, if you will, or the deception place, or the truth-telling place. It's unlikely that's likely to be at one particular place, but we don't know that. And that's important with regard to the legal system. Let me give you a specific problem that arises. How do we know the difference with regard to the brain when someone is lying, concealing, or poor memory, and what does that mean for the legal system? For example, we know that people can intentionally lie, okay? We also know that people can deny something that he or she knows is not the case. That is, I'm just not going to tell you something. I'll leave it out. Is there something in the brain which tells us, oops, he's left a important piece of information out? And then a person believes he or she is telling the truth but is not, called the to the best of my recollection, if you will. That is, I'm actually positive that such and such happened, that person at the scene of the crime was carrying a gun. And she or he believes that. But we know for some other reason, evidence, whatever, that that's not the case. But how do we detect that in the brain? We have a way to go before we can get to this point, and all of this is really quite crucial, as you can imagine, for the legal system. But these are the questions that have to be asked. So the next obvious point is, well, what happens when we can answer all of these questions? What if the fMRI really can become a truth verification machine or a lie detector of considerable accuracy and precision? What are we going to do? Well, I think we have to be fair to people who are in our legal system, for reasons they prefer not to be, that we provide the best technology and science that it has to offer. Certainly their legal counsel will want that. Certainly we would want it if one of our family members was involved in some activity in the legal system. So the question is whether or not we will get to this point where the technology, whether it's this technology in terms of lie detection or some other neuroscience technological advance, we'll all agree has to be part of the system, just as we now argue for more DNA, for questions of justice and fairness, knowing the strength of the technology. The question is it going this way? So let's assume that we can do this, that we can get to the point where we overcome some of these technical hurdles. Here are some interesting questions that I think it raises for the legal system and society generally. To what extent might efforts to examine brain activity be a violation of an individual's privacy? And does that matter depending upon what the legal issue is? Murder versus shoplifting. Yeah.
That would only occur if the machine become advanced enough to actually see past actions of a person. Otherwise, right now, I can't see that one really being an issue. But in the future, I reckon it could be an issue, but only under certain circumstances.
Well, right now it's not an issue. You're absolutely right. But if I have a technology which will tell me is he lying or not, so I'm sort of invading his brain in order to find out whether he's telling the truth or lying, and that's basically I'm trying to find out what you're thinking at that very moment. I'm doing the test. And I think it's a fair question to at least begin thinking about as to whether or not you are violating someone's privacy when you are trying to figure out what he or she is thinking about. That's a lot, it seems to me, that's different than what we would call more physical evidence. You can now basically require that a prisoner or an accused person, et cetera, give blood, give us a sample from his cheek, et cetera, some hair, for analysis. That's all physical evidence, which I guess that leads me to my next point. We'd have to consider, it seems to me, whether what's produced by the fMRI is physical or cognitive evidence, and what the implications of that are legally. If indeed it's cognitive, or physical, is it basically the same as a blood sample? Are we asking anything more? Yeah.
Well, is it the same as a blood sample, or is it actually to the realm of is it self-incrimination?
Well, I'm getting to that, but yes, that's a good point. Keep that in mind. And if it is cognitive, should the legal system be able to compel, as it can now with physical evidence, a defendant to undergo an FMRI? It doesn't matter if the defendant has a history of claustrophobia. Documented, well documented. Do we care? Does it matter whether it's a civil or a criminal case? There are a lot of things we have to ask ourselves as the science advances as to how it might be used. Again, we're not at that point, but to get to your point, if we are able to quote, I put this in quote marks, read your mind, or figure out whether you are lying or telling the truth, are we getting you to the point where you are potentially self-incriminating yourself? And of course, we have a constitutional right not to do that.
Currently, if people are asked to give DNA from the cheek, they can say no unless there's a court order saying they have to do it.
Right, but they have to do it if there's a court order.
Yeah,
And if they refuse to comply with the court order, that's the first thing that's going to be said in a criminal trial. He refused to comply.
And yet you can refuse to testify. And,
That's right.
You know, so it's, you know.
So there are trade-offs. There are trade-offs. I think neuroscience is going to lead us to some interesting trade-offs. That's the point I'm trying to make, that we need to be thinking about. Here's an interesting point. Will this evidence, if you will, be mitigating in its effect, insofar as showing a diminished capacity leads to a less harsh sentence, okay? You know, he couldn't help it. His brain made him do it. I'm exaggerating a little bit, but surely we all recognize, and we know, we have evidence, tumors on the brain could change the personality of people. Illnesses, et cetera. We know what happens. So will it lead to mitigating factors in the legal system, a less harsh sentence? Or will it be aggravating in that it indicates future dangerousness that will warrant greater surveillance and control of the individual? This, it seems to me, is a big question. The Bible has this wonderful quote, "Then you will know the truth, and the truth will set you free." But in the criminal justice sentence, it could lock you up for a very, very long time, depending upon how we interpret it. So, I mean, these are tough issues that we're going to have to be thinking about with regard to how neuroscience might affect our legal system in ways different than DNA does, or forensic science, tool mark analysis, hair analysis, so forth and so on. And I think that these are the kinds of issues that I think the scientific community has to be engaged in. And I'll say a bit more about that a little later. The last major substantive point that I want to talk about is something that we all have but lose over time to different degrees, and that's memory. And the reason memory is very important for the legal system, well, there's several reasons, one of which, of course, is an eyewitness. What do you remember happened at the moment of your observation of some sort of behavior? But also jurors, particularly over long trials. A lot of evidence could be introduced. Once they get into that room, what do they really remember, and how accurate is it? So I want to share this description with you of memory. Bartlett is considered to be one of the leading psychologists of memory research, and very useful description. Memory is not the re-excitation of innumerable fixed lifeless ideas and fragmentary traces. Here's what it is: an imaginative reconstruction or construction built out of the relation of our attitudes toward a whole active mass of organized past reactions or experiences, and to a little outstanding detail which commonly appears in an image or language form. So the important thing to understand is that memory is not linear and accumulative. It just doesn't work that way. It doesn't work that way. Well, maybe I should show you the next slide. This is how memory works. You have 3 stages of memory. Encoding, that's when you take it in, such as what I'm telling you today. Storing, what you do with it when you leave today. And retrieving, what you remember about what I said today. And we know that the quality of memory can be compromised at any of those stages, leading to no memory, incomplete memory, or false memory. And there are so many really good studies which show this, how various factors compromise, such as leading questions in the courtroom, emotional or physical trauma, age and time, disease, planning suggestive thoughts, misinformation. All of these factors have been demonstrated to affect memory. And there are instances where people can be told something that is known not to have happened to them, but sometime later when they're quizzed about it by a researcher, they remember it as if it happened to them yesterday, planting false memories. Okay? So think about that in terms of the power of eyewitness testimony, where you're witnessing a traumatic event. It's happening fast, most likely. And you're not asked about it until 16 months later, as the case may be. You may be asked about it initially by a police investigator, but in the courtroom, so when people say, you know, when an attorney says, well, wait a minute, that's not what you told the police. Do you really believe what you're telling us now is the truth? And they will say yes, and they probably really believe it, but they have changed the way they think they saw it back then. Yeah.
Yeah, actually that's connected to there's studies that point to that even recalling a memory changes the way it's stored. So if you recall it under certain circumstances, new things are injected and now are composed into that memory. That's
right. And if you're talking about it with your peers and they have different experiences, all of a sudden you'll end up having ones very similar to theirs. How did that happen? And again, none of this is abnormal. Bartlett's description is the way memory works. There's powerful evidence of that. So none of this equals intentional lying at all. But the imaging technology we have just can't figure out how to weed those things out. I mean, that's still really very critical. So there's a link, there's a link between memory and eyewitness testimony per se, but there's also a link between memory and the notion of lie detection. And that is the ability by the technology, which does not exist, to be able to distinguish between telling you a lie, concealing something, failing to tell you something, and basically being absolutely sure what you're telling is the truth when we know it isn't, because memory gets distorted over time. This is the challenge that neuroscience faces with regard to the technology being used in these kinds of contexts. Well, I've already hit on this to a certain extent about the eyewitness testimony, but let me emphasize this point here. Have you heard of the Innocence Project? Using DNA to exonerate people? It's interesting to note this. Eyewitness misidentification testimony was a factor in 75% of post-conviction DNA exoneration cases in the U.S., making it the leading cause of these wrongful convictions. So that in itself is pretty powerful testimony, if you will, to some of the problems associated with eyewitness testimony. So it's not a trivial matter, but it's a real problem because our system depends so much on it. So can science help with regard to memory? And for some of us who are getting older, we might be interested in this question, just generally speaking. There is some research that is going on that it may be possible to improve memory, even as time goes on. And that for the most part, many of them or most of them are involved in memory retrieval processes, because certainly encoding, if you don't take it in the first place, you're not going to remember it. You might make it up, but you're not going to remember it, if you will. So there is some research going on, and the question that one might raise is, what if this research really pans out? And we can have a pharmaceutical, or in this case, no, that has to go there. You can use brain surgery to improve memory, or magnetic stimulation. They're not ready for the legal system, but what if they could work? Would we require witnesses to take the little drug, or to be magnetically stimulated a little bit? And to paraphrase the person who mentioned this earlier, What if they got on the witness stand and the opposing counsel said, "You didn't take that, did you?" "No, I didn't want to take it." Is the jury going to draw inferences from the fact that must be lying because she didn't want to take that?
Well, you can say the same thing about when they plead the fifth.
Yeah.
Well, witnesses can't plead the fifth.
No, witnesses can't plead. But the point is, these are witnesses. They're not involved in the crime per se. Okay, but they're very important to our system of justice. If we now know that memory is so bad, and we now have a technique to improve memory, should we provide it as an option? Should we allow lawyers to pay excessive fees to get witnesses to take it to improve their memory? Should we require it under any circumstances, such as some sort of mass violence resulting in hundreds of people dying, perhaps? Yeah.
Well, and then you'd have to go into the ethical ramifications of forcing someone to re-remember all of that stuff if it were traumatic.
You would, indeed. That's another very good point. What if the memories would really hurt that person in some way, cause them serious harm in some way? So, I mean, I don't have answers to these questions, but I do have lots of questions, and I'm more than happy to have some conversation about them. That's the point I just made. Again, should juries be told whether or not someone was willing to undergo a memory enhancement and what the implications of that?
Should the jury be tested too with the FMRI?
Well, I don't see the day, but who knows? I don't see the day when, as someone said about getting jurors, and also the at this stage, of course, it's a very arduous and expensive procedure, etc. But we all find ourselves skeptical. Of course, all of you are skeptical all the time, right? About some of these decisions that come out of juries, and you often wonder, what were they thinking about? But nevertheless, I don't think it's a question that will probably come up someday. Yes?
How would we even know that the memory enhancement had produced, say, an objective memory? I mean, how could something happen and they were the only witness, there's no recording of the event? How would you know you didn't produce certainty of some false memory?
Well, we don't necessarily expect certainty in terms of either science or in terms of the legal system. But to the best of my knowledge, based on my taking this pill or whatever it might be, it suddenly clarified things for me. And the science tells us it has a certain degree of reliability, and with certain kinds of people, so forth and so on. Taking that into account, we're not anywhere near that, but taking that into account, what would we have to do if we could do it? If we could do it, what would that mean? Would it be if the jury knows that person took that? Would they give much more weight and credence to that evidence? And should they? Because there's always a chance it isn't 100%. It probably, in some cases it won't be. There was another point. Yes?
I'm sorry, I came in a little late, so if you already discussed it, my apologies. But I was wondering whether testimony under hypnosis is any more or less reliable.
That's a good point. And, of course, the courts have differed as to whether or not they allow this testimony in, depending a lot on the qualifications of the hypnotist, if you will. What can be said about the susceptibility of some person under what the science tells us about hypnosis.
I think in Virginia they don't allow witnesses who've been hypnotized to testify.
Oh, were you talking about witnesses?
Yeah, I guess so. Eyewitnesses.
Well, I guess witnesses could potentially volunteer to go through the process. Whether it's admitted as evidence would depend. If it's a federal court, it would depend on those criteria I had earlier. You may have missed it from the Daubert case as to what the science tells us. If it's a state court, then it's sort of up for grabs as to what the state allows and doesn't allow. They have.
I think the state of Virginia doesn't allow it. In fact, they will exclude testimony if somebody's actually done it on their own and their memory enhanced by hypnosis or supposedly enhanced. they will exclude it. In one case, that actually had a case reversed because a witness had done that, and then the court later discovered it. And they threw the conviction out.
Yeah, second row.
I'm not sure about the specifics of Virginia, but I know that there are guidelines for psychologists practicing hypnosis about how to do it such that it will be admissible, to increase the chances of it being admissible in court.
Yes, and that is it's a good point, because there are a lot of guidelines out there that are aimed at scientists/physicians who may end up testifying in a legal proceeding, to help them understand, number one, what the expectations are in the legal context, and then number two, to remind them of what their responsibilities are from the point of view of science when making claims about whatever it is. Hypnosis is one, but it's sort of called forensic evidence because it's used in the legal system. And a number of professions. Engineers testify a lot, and they have certain guides and guidelines. Physicians a lot, and even specialty physicians have them. The psychologists have them, and others that I'm not thinking of off the top of my head. But that is an attempt, and I think that's a very good point. That's an attempt of the scientific community or discipline involved to try to be helpful to the legal system, while at the same time recognizing that there are both limits and capabilities attached to every scientific discovery and application. And so they have taken it on themselves to voluntarily develop these kinds of guidelines. And some of them are probably very good, some of them may have some weaknesses, I don't know, but nevertheless they do exist. It's a good example, I think, of scientists trying to make sure that whatever gets in represents the best science available if you are a member of our organization and you're covered by our guidelines. Yes?
What I'm hearing and seeing from all of this is that there really is no good, reliable way right now. For example, we know that eyewitness testimony is really not, valid at all. We know that this is not going to work for a long, long time. So we have DNA and we have blood evidence and things like that, but those are the pure sciences. They have nothing to do with the human brain at all. If you know what I mean. It's not like somebody telling something. It's not like somebody being tested for something. It's not even the galvanic skin response. It's just DNA doesn't need any of it. You don't need the person.
No, but you certainly need a scientist to interpret it.
Oh, absolutely. But isn't that fairly regulated in terms of...
Reasonably so, reasonably so.
I'm reading a book called The Murder Room now, which is about true cases, and talking about the first case in Texas where you didn't need a body to prove murder. And it was only fairly recently, because there was so much blood evidence that they finally said that that's part of the body. And they did have a piece of the body through that, and were able to convict somebody. It was very interesting.
Yes.
I don't know if this is the time to bring this up or whether there'll be questions later, but you've mostly spoken about memory and truthfulness. And I think neuroscience can give you so much more that could impact a trial. As like the example of a tumor on the brain, which isn't really neuroscience because it's structural. But they're learning so much about the brain and what people are doing because of what goes on in their brain. Or, like an example, that the brain isn't fully matured until about 25 years of age. And until then, people can't think forward to the consequences of their action.
Well, there's actually some reason to believe that the Supreme Court recently, in its decision concerning whether or not people under 17, juveniles, could be executed, took some of that into account. They took behavioral science into account, not neuroscience, in the death penalty case, where they said basically in terms of mental retardation, if you look at some of the amicus briefs in the court's opinion. So I mean, that's a good point. You could say, for example, courts deal with all sorts of decisions that have deal with broader social problems, like equity in education. Well, we want to know maybe to what extent do people have various mental impairments that slow them down in the educational process, and what should we do? That's a legal decision would come out of that. I only had so much time, and I guess I focused on those that I felt reasonably comfortable with. But, I mean, there are just a variety of different places within the legal system. At the very early part, I was talking about competency with regard to wills, learning problems. All of those things could ultimately get into the court system. So you're right. There are just a lot of ways.
Well, you're talking about hypnosis. There's an article in the Skeptical Inquirer many years ago about, it had to do with UFO abductions, and psychologists seem to agree that you were really no more likely to tell the truth under hypnosis than you were normally. Of course, if the person was asking leading questions, like some of the, was Bud Hopkins did, then of course you're going to make up, confabulate everything.
Yes, you may well distort whatever accurate memory was there by the way you go about it, which again is one of the reasons that the courts do come down very hard on the qualifications of the person doing it. But let me just finish up with a couple of slides, because this is sort of my take-home message that I suspect is pretty obvious by now. What's happened is what happens in a lot of science, and that is we generate large volumes of data, but we really don't know what it all means. And we're still at that stage in terms of neuroscience. We don't have good theories. We don't have really well-received, tightly believed interpretations. So we have a way to go before we get involved in the legal system. But the point is, things are happening, okay? Lawyers are trying to get stuff into the legal system. It's happening, okay? And they're getting scientists to testify. So we have to keep that in mind. And then even if we gain the power to identify or predict certain antisocial behavior based on these brain abnormalities, should the legal system become less punishment-driven and more therapeutic? This is a big question. If we determine that a lot of what's going on in the brains of people who are criminals is because of some sort of brain anomaly, if you will, beyond their control, should the criminal justice system think more about how it could rehabilitate, help these people, than punish them? Yeah.
But actually, doesn't that bring up, from the lawyerly perspective, Oliver Wendell Holmes's little judgment about how 3 generations of imbeciles was enough, and so we sterilized someone with the court basically taking the science as quote-unquote great, good, and misapplying it, and so your therapy may be more harm than good.
It may. I mean, I'm not passing judgment on this. I'm just sort of raising the question. You know, the legal system itself could misuse some of these things, and we just have to think very carefully. Just as any other branch of government can misuse advances in science or technology, or individuals can misuse it, etc. We just have to keep this in mind and do our best to put in place mechanisms, oversight, etc., and educate people about what we can or cannot reasonably expect of these technologies in the context of this system. I'm just simply raising the point that others have raised too, that, you know, if you've got something wrong in your brain, I mean, all behavior really originates in the brain. And if you have some abnormality there, as we may eventually define it, and we can now, then maybe we ought to look back and say, well, maybe the answer is not so much incarcerating you for the rest of your life, but giving you some sort of treatment. Or, if you are incarcerated, giving you some sort of treatment, which in theory happens now, but we know doesn't really in many cases. So 2 more points. There is, I think, clear that we have a biological basis for behavior, and behavior originates in the brain. But whether one is held legally responsible for a criminal act, and I want to make this point clear, whether one is held legally responsible for a criminal act is a legal determination and not a scientific finding. So neuroscience can help evaluate behavior, and one's ability to control it. That is, whether I acted on impulse and just couldn't control it and killed somebody. But it can't determine how much control is required to be considered responsible under the law. That's a society decision. So we could end up, for example, changing sentencing laws, changing all sorts of criminal procedures to accommodate neuroscience at some point in time. But ultimately, it's the legal system that makes the decision as to whether or not someone had sufficient responsibility to be judged and face some sort of punishment. And then finally, this is the point I alluded to earlier, and that is that I think neuroscientists or anyone who is associated with these kinds of studies need to think about some of the social impacts of what they're doing are likely to be. One context, and only one, is the legal system. And clearly I've probably shown you enough here to at least generate some possibilities that, yeah, neuroscience is we're going to learn something from neuroscience that's going to contribute to the way our legal system works. And we have to think about it. So my point here is that scientists have professional responsibilities beyond just what they do in the lab, and they need to become more engaged. So the point earlier made about the disciplinary societies developing guidelines for their members when they're testifying in court is an example of an effort on the profession in that case to take some sort of action to recognize there are issues, there are problems. Let's set up some guidelines as best we can. So I think I'll just close my formal remarks by saying that AAAS has had a project since 2006 whereby we organize seminars on neuroscience for judges, federal judges, state judges, and administrative law judges. We hold 2 or 3 a year. We're going to be doing them again next year. They're funded by the Dana Foundation, which is a foundation in New York, the largest funder of neuroscience basic research in the U.S. outside of NIH. And it's an effort not to make judges neuroscientists, but to at least get them to the point where they might be able to ask the right questions and show some skepticism when attorneys make claims, whether they're on this side or that side of the issue. And when it comes to admissibility, this is where they have a formal role. They are required to consider these kinds of things. And so I think scientists can help get engaged, and AAAS has taken this on a small step at a time, since there are lots of judges out there and we only do seminars, so we keep them rather small. But this is one effort on our part, and there are other groups that are also working in this regard in trying to work with the court system in terms of how some of this new neuroscience may or may not be dealt with in the courts. So I will stop my formal remarks and thank you for your attention. I hope you remember some of this after you get home, but I'm not counting on it. But so we can have a discussion now for what, 10 minutes?
More or less.
More or less? Yes, sir.
Back in the 1990s, I was on a series of panels for the National Institute of Justice and looking at research proposals. And I had a guy that kept submitting a proposal. He claimed that he would develop a type of brain scan where he could not tell whether someone was lying or being truthful, but could determine whether somebody was familiar with an image or not. And the idea was to cycle through innocuous images and intersperse those with images, perhaps from a crime scene, and then see if the person was familiar. So it's kind of like the guilty knowledge kind of test. Has anybody been doing any more research in that area?
That's the P350. That has not been accepted in any court. There's only one case, I think, that's actually dealt with it directly and was not accepted. The scientists that I talk to don't put a lot of credence in it. This fellow, whose name escapes me, it's Larry or Lawrence something, he has a website.
His name escapes me.
I don't remember. That's the memory thing again.
We didn't fund him either time he submitted.
Yeah, it's not a well-accepted process, but it had to do with familiarity of things that happened at the crime scene.
I think he named the phenomenon after himself, so I
Yes, sir.
In recent years, there have been a number of cases where police crime labs and even the FBI crime lab have skewed their findings to get the result that the police or prosecutors want. What assurance would we have that private companies with a huge profit motive wouldn't do more of that?
Well, I mean, I don't know that we have many assurances, but if they were found out, that might be the end of their business career and maybe time in prison. That's true of life generally. So, I mean, if we know we've had that experience with other kinds of evidence, if you will, tampering, skewing, whatever, then there's no reason to believe it's not going to happen with any of this evidence, and we just have to be alert for it. Absolutely. Let's see, back there? Yes, ma'am.
Two questions. One is, knowing how easy it is to implant false memories, why is lying to suspects allowed when that would lead to false confessions? And the second part is regarding the guidelines for the admissibility in federal court in terms of science. I've read studies regarding medicating people to get them competent to stand trial. Those are done by people that are within the prison system. How can that be allowed when it's partial, when it's not independent?
She's right. It was a Supreme Court case, I want to say in the 80s, that basically said they can do it under certain circumstances. They could basically medicate people if there was some evidence that the medication would have the effect they were claiming it would have, so that they would be able to participate in some sort of proceeding, whatever it might be. And whether or not the person could basically refuse, keeping in mind that the person was presumably so ill that they weren't competent to consent in the first place. There are a lot of people who are very upset with that court decision, and there are a lot of people who thought it was an advancement, if you will. But it has, I can't tell you the precise wording of the decision, but it has something to do with the fact that you lose some of your rights when you become convicted and imprisoned. And that's the way things are. But while that's true, we do have to have certain procedures, and the court laid out a number of procedures, which I don't remember what they were, that one would have to follow. And you have to go through a whole procedure, and a judge has to agree that, yes, you can medicate that person.
But the studies being used are done by the people within the system, because you cannot have independent people that have prisoners, and have the independent view of things.
That's right. You're right.
So it's a little bit skewed in that respect.
Yes. I mean, it
Can
is.
there be some independent knowledge if they had a doctor prior to that?
Well, you're usually
records?
dealing with people that do not have money and things to have independent view of things. So.
Well, there'll always be, if it's at the federal level, there'll always be a provision that will allow for examination of the patient by more than one person, and then the lawyers are allowed to tell the judge who they'd like to, what his credentials are, and so forth and so on. Wait a minute, there are too many here. Yes, how about over there? Yes. Did you have your hand up? I'm sorry. Yes, sir.
You alluded to this in some of your closing remarks in terms of control, but I didn't really see too much in the talk about this. I was wondering more if you have some comments in regards to causality and responsibility, and how neuroscience and brain science in general is sort of beginning to show how much external factors affect the sort of everyday decision making, and even you can sort of take it further with some studies showing that at least certain types of decisions are made before we're even consciously aware of them.
Yeah, I mean that's very interesting experimental designs, very interesting findings. Has a lot to say about free will, responsibility, and I don't want to say too much more than that. It's I mean, from my point of view, it's a quagmire to get into that now, and it's a foundational, very important question that has a lot of philosophical underpinnings as well. There are people who feel that even if the science shows that, people are still making decisions and should be responsible for them. Whether they also believe that it should be a mitigating factor varies. It is a set of issues that are being discussed. But it's not one that I typically engage in. I just I like to try to focus on things that I think at the moment or within a certain time frame are a little bit more practically oriented. That's a big question, and one that I just don't have anything to contribute. Yes, ma'am.
In some of the earlier slides, you mentioned the question of privacy, invasion of privacy.
Oh, privacy, yes, ma'am.
And you said something like, if it is physical, it's okay. If it is cognitive,
we don't know. I didn't say it wasn't okay. I'm just raising the point because we don't have that. We've never had that power before.
Okay, I don't understand why you make a distinction between physical and cognitive, because everything is physical in the brain. And another thing is that the FMRI is only getting physical results.
Yes, it is measuring physical indices of what's going on in the brain. That's correct. Now, if we get to the point where we can interpret those in a way so that we can tell somebody is truthful or someone is lying or some other deep thoughts that are going on in there, then we are getting into territory that I think will be perceived by many as being not physical anymore. That is, it's the physical activity which combined leads to thoughts, if you will. And that's an area where we haven't had, the legal system has not had to confront it. My point is that if you believe that what's going on in there is somebody's thoughts, what he or she is thinking, and they have every right under the constitutional provision of self-recrimination to keep them to themselves. Just as, you do in terms of ordinary life. Forget the criminal system. Do you want people being able to read your mind, if you will, and know what you're thinking? Is that at a different level than to know physiologically what's going on? Now, I wasn't making a case for or against. I'm simply raising the issue that there are people who feel very strongly that when you get to the point of being able to interpret what's going on that leads you to decide that he or she is thinking this or thinking that, then that's at a different level than a blood sample or hair sample. And it's just an issue that we have to think about. You will feel one way and someone else might feel another way. All right, now, this gentleman here in the blue has been waiting for a while. All right, well, let me, go ahead.
Okay, science is pretty much, I think, scientists that study this are in agreement that eyewitness testimony is not reliable or not terribly reliable when compared to all the other evidence that can be brought to bear in a court case. But you talked about the distinction between science and the law, and so I'm wondering if the law has caught up to science in down or diminishing the credibility of that testimony. The reason I ask is because there was something in your talk that sort of assumption that with more understanding of neuroscience and the improving of the equipment to test what people are thinking, that's going to increase the credibility of eyewitness testimony because it provides sort of like an independent verification. But isn't there also a possibility that the more we know about the way the brain works, that we're not going to be able to verify what people are telling us, or we're going to discover that what people say is really unverifiable, and that would actually finally put a final nail in that coffin of eyewitness testimony and move sort of the burden of evidence in a court case to the sort of physical and verifiable?
Yeah, well, I want to be careful what I said and what I just was raising as an issue. I think it's very possible that more neuroscience evidence will make eyewitness testimony seem even less credible or more credible. I mean, it could go either way, particularly if we have techniques which can improve memory and we can somehow measure and document that. So it can go either way. But there are judges who are on their own thinking about their instructions to the jurors with regard to eyewitness testimony. And there's some research that's going on where you set up a mock situation and you have different people acting as judges giving different instructions to the jurors. This is before they go into the, and making it clear that what they should be paying attention to is this, which may in this case be eyewitness testimony at that time, as opposed to that, which may be the lawyer's questions and what the lawyer is saying. Because in a sense, the lawyer could be planting ideas in the jurors' minds. I mean, all of that's part of his or her strategy, if you will. So, will neuroscience give us a more, quote, scientific basis for evaluating the value of eyewitness testimony, which may be this much value as opposed to what it has been in the past? I suspect it will. I don't know that we'll ever do away with it. It's so ingrained in the system for you to have people testify on your behalf is your right constitutionally. But what might happen is that the system will develop mechanisms to educate all participants as to the value of such testimony. And there may well be a way of getting at the value for that particular witness through some sort of neuroscience testing. I don't know. A lot yet to play out. But it is challenging the way we look at eyewitness testimony. That has actually happened. That's happening now in the system. But there's no formal way of trying to deal with it. Judges individually, I know around the country, have taken that into account. And in fact, in New Jersey, the New Jersey Supreme Court came out with an opinion in 2011, which basically gave guidance to all judges about how they should deal with eyewitness testimony with regard to admissibility and with regard to jury instructions. So the state of New Jersey has now more of a uniform guidelines on that issue. So you raise a good question, and I think there's trying to respond, but we're going too far, I guess. Okay.
Once again, thank you for...
You're welcome.